And welcome back to the show. Well, in recent news, lawmakers passed a bill to extend eviction protection for tenants affected by the COVID-19 pandemic. Now, this new extension will continue to ensure that New York tenants, as well as homeowners and business owners, as well as small landlords, will not have to fear losing their homes or businesses. But the real question is, what will this actually mean moving forward? Joining us now to share a little bit more about these details is the partner at David A. Gallo Associates LLP, Robert Link. And Robert, good to have you back. And I'll start off like this. We did say a year ago that when this extension was going to happen, you predicted actually a year. Nobody actually predicted we would be to this place. And now a further extension into August. What does this all really mean?
It's funny you say that, Darren, and thanks for having me on. When I came on about a year ago, you asked me, when are we going to see things pick up? And I think I said, it's not going to happen. And at the time, I think you were kind of taken aback by the fact I said, nothing's going to happen in the year 2020. You know, we're going to wait till 2021 and then things are going to pick up. Now we're here in 2021, and I think the news is really things aren't going to pick up to 2022. This most recent law, what it does is any case where a hardship declaration is filed, and right now that's about 40,000 cases, but with the announcement of the law, I think the expectations are that number is going to significantly grow. If you file the hardship declaration form, you're safe. You cannot be evicted until August 31st of 2021. Now, what happens after August 31st, 2021? If there's a further extension, it remains to be seen. Lawmakers won't be in session August 31st. At least they're not scheduled to be in session at that time. So they would need to come back into like a special session in order to, extend a further moratorium. But you got to read this law in connection with the $2.4 billion that was passed with the budget. That $2.4 billion is dedicated to paying off past due rent arrears. So landlords or tenants who are in default more than 12 months can try to get a piece of that money and apply it towards their rent arrears. And the landlords, if they accept that money, they cannot evict. So that's where we're headed. We're going to see how this program is promulgated, and we're going to see the next steps from there. But we're a long way away. Now we're over a year into this process. We are a long way away from business being back to normal in the housing courts, particularly in New York City.
Yeah, but you look at that $2.4 billion. I've talked with several landlords who said, listen, if I don't get my hands on any of that, I could potentially be stuck. And $2.4 billion sounds like a lot of money, but the reality is when you go across New York City, you go across New York State, that money can be dried up quickly, particularly with the amount of people that are currently in arrears. The question I have is, what other recourse does a landlord have if I don't get my hands on that money and I still got a tenant who's not paying there?
Well, you're 100% right. It's probably not enough money for all the default that we had. And by the time it gets delivered, people are going to be 12 months in arrears, 18 months in arrears, 2 years in arrears by this time the money gets handed out. So the question becomes, now what does the landlord do? What we're seeing the landlord do, particularly in the commercial context, but you're also seeing it in the residential context, the landlord says, well, I'm not going to wait around for some indefinite amount of time when the courts put my case on for a calendar hearing or this moratorium is up. I'm not going to wait. So they're bringing, against some tenants where you have a guarantee, and they're bringing collections actions. So, I have restaurants or a hookah lounge where, they're personally liable for the payments under the lease. The tenant is personally liable. So you'll see, rather than bringing the eviction, they'll bring a collections action, which is right now permitted. Now, there are some protections in New York City where there's a third party. Let's say my dad or my mother-in-law guarantees my lease and my default is limited to a COVID-19 period. Under New York City, most recently passed New York City law, in my hypothetical, the landlord couldn't go after my my mother-in-law for that portion of the lease. They'd have to go after me directly.
Yeah. Let's play this scenario out. Let's say we go all the way to the end of this new moratorium, and I still got a tenant, and that tenant has to be evicted. Well, now we enter into the court system. Here you come. Let's talk about this, because once you put it out there in the court system and you file the necessary paperwork, just because I'm trying to evict possibly in August, I may not see a potential court date until when? 2022?
Oh yeah, definitely 2022. Listen, if you go to the this part of me thinks, really this extension of the moratorium to August 31st really isn't that big of a deal. It's really only 40,000 cases. We have hundreds of thousands of cases that are already out there that no one has filed out a hardship declaration, that may be already in the system, have been pending for a year or more in the housing courts. So from some aspect, this isn't that big of a deal. What is a big deal is that we're really not processing the housing court cases that are there. If you go to the Bronx Housing Court right now, you go down there today on the Grand Concourse, there's a line that goes down the street. They let in one person at a time, and you get to speak with a clerk. And then after you speak with the clerk, you get to leave the line. Maybe you file your hardship declaration. Maybe you get information about an adjournment. You leave that line, and then they let in a second person. Now, in addition to that, they're doing remote hearings. In some cases are moving forward with trials and conferences and whatnot. But we are not even close to handling the cases where there is no hardship declaration in an expedited way or in a routine or normal way. In fact, I think the Judge DeFiore, the head of the Office of Court Administration, just announced this week that they're starting to return full staffing levels, 75, 80% upstate. So perhaps that is an announcement or an indication that things will pick up, but I'm not expecting a significant amount of evictions in 2021. This is definitely going to be put into 2022, probably the summer of 2022, before you really see a real uptick in activity.
We've heard the popular phrase in the business world, the customer is always right. But when we look at these moratorium laws, it looks as though the tenant is always right. So give me, from a lawyer's perspective, what kind of counsel do you give a landlord who may have to stick it out for an extended period of time now?
Well, I've been saying it since, more than a year now, speaking to my landlord clients and the tenant clients, make a deal. If there's an opportunity for you to take some money, a portion of the money, you want to make the deal. You also want to see if you have a guarantee on your lease, and you want to consider the idea of bringing a collections action. And the other thing that the landlords have looked at over the last year and a half is challenging the constitutionality of some of these laws. There's an understanding that a contract is sacred in the law. Right. So, and in fact, the federal Constitution provides that the government shall not impair an existing contract. That's kind of been set aside, or there's been an opening for interpretation of that general principle because of the severity of this pandemic and this just once in a lifetime nature of this pandemic. We're seeing exceptions to that. And a lot of the actions that have challenged the constitutionality of these laws have failed thus far. So perhaps at some point in time, the courts view this as an overreach, but that's really the only check at this point. The only other check is, I would say, watching some of the debate this week, you are starting to see some of the more moderate upstate Democrats side with Republicans in being a little bit more reluctant to support some of these very pro-tenant moratoriums and extensions of the moratorium. So we'll see where that goes. And I do have to preface one other fact, that Governor Cuomo hasn't yet signed off on the August 31st extension of the moratorium. That could come any day. That could come by the end of the week. I anticipate it's going to come. But a lot of times he likes to put his thumb on the scale and give his imprimatur on matters that are pending. He still wants to show his relevance, and whether or not he raises any objections that cause an amendment to the law or a reconsideration of the law, we'll have to wait and see.
Yeah, it's gonna be a wait and see approach. But in the interim, though, a lot of things to really be able to hash out. If you're a tenant, let's play this out too. And you've got a tenant landlord dispute prior to COVID. Where do you stand right now by way of the court system?
What the court system should be doing is that they should be having a conference. The moratorium says that if you have a warrant of eviction, right, pre-pandemic, pre-March of 2020, if you are already as a landlord entitled to perform an eviction, to carry out the eviction, before that eviction goes forward, you have to have a conference with the court and with the other party, and they have to check and see that they got somewhere else to go, and see if they may be eligible for aid under the COVID Relief Act, and look at all of these options. So that is one thing that's going to be taken into consideration. The other thing the law does is if you have if you have a case that was pending in front of you and they haven't had a judgment, the court hasn't, or the landlord hasn't obtained a judgment against you yet for failing to pay the rent or for holdover or for whatever, the landlord has to prove, and the court has to actually conduct a hearing to see whether or not you had an opportunity, you were served with a blank hardship declaration form. So whether or not the court is going to have an opportunity to conduct, thousands upon thousands of hearings to make sure the tenant received this form remains to be seen. It's going to be done virtually. Some tenants are going to have an opportunity to appear virtually, because of internet access or whatever. So we're going to see how this all plays out, but it really puts a gum in the works of an already overburdened and complicated system.
Well, when I first met you about a year ago, you did have a prediction. I'm gonna come back now, a year later. What's your prediction?
I think, maybe summer of 2022 is what we're probably looking at. We're going to start to see some of this money be handed out, some of the 2.4 billion. It's going to become evident that either there's a good amount of money to go around, or this isn't even a drop in the bucket. And then you'll start to see, these courts take cases on little by little by little. And first they'll deal with the defaults from pre-March of 2017, and they're going to deal with everything that was filed over the summer and has been sitting without a court hearing date before that. And then, there's going to be defenses that are going to be interposed that the courts have never dealt with before. There's been numerous executive orders, there's been new laws, and there are going to be attorneys advocating for one interpretation versus another interpretation of these laws. And those cases are going to go up to the appellate term and the appellate division, and we'll have an idea what exactly those laws mean. So, this process of appeals and interpreting the laws and getting through the system, it's going to take well into 2022 to really have a meaningful look at a majority of the pending cases and get an idea of where this is going for the next 2 to 5 years.
Yeah. So I guess the long and short of it is there's going to be longer, and there are no real short-term wins here.
No, this is an immense, once-in-a-lifetime situation. The courts are not prepared to handle it. They're opening the door ever so slightly so that we can begin to look at some of these cases. We can distribute the $2.4 billion, and how it ends up is anyone's guess. But I can tell you from a certainty, it's going to be very, very slow.
Yeah. Well, Robert, thank you so much for being with us again, bringing us up to speed. Of course, we will continue to follow these developments and more as they continue to unfold. And they seem to unfold kind of rapidly and unexpectedly. But thank you for bringing us the updates and bringing us up to speed.
Darren, thanks a lot. Glad to be here.
All righty. For more information, you can find out more about Robert at his website. And listen, we encourage you stay connected to us here on Open. We'll continue right after this.